Hello.
Hi there, folks. Sorry for the delay and apologize that the links seem to have been got crossed, but I think we are all present now. So this is the time set for oral argument in 1 CACD 20-0338, Travelers versus Bollschweiler et al. We are doing virtual arguments. So I'm just going to ask, before I start through the rest of my introduction here, Mr. Kroger, can you hear me?
Yes.
And Mr. Arnett?
Yes, I hear you well. Thank you.
All right, and I can hear you, and I'm not seeing any indication that the other folks can't. You have a maximum of 20 minutes per side, although you are not obligated to use all of that time. We do require you to keep track of your own time, especially in the virtual world. That being said, I am also keeping track of the time. I will, from time to time, interrupt you just to give you a signpost. You are welcome to ask me if you want to know where you stand. If you do want to reserve any time for rebuttal, you do need to do that on your own. And I can reset the clock with whatever your remaining time is. I know it is an unusual situation, but hopefully you can see everybody and make sure that you can respond appropriately if there is a question from the bench. Please keep in mind that we have read the briefing, we have studied the record, and we have discussed the matter extensively in conference today. What I'd ask you to do is focus on the key issues, and with that, you can proceed.
Thank you.
Judge Goss or Mr. Arnett, I can't see Mr. Arnett. Maybe it's just me.
I can't see him either.
I thought it was just because he hadn't spoken much. Mr. Arnett, can you make sure?
Yes.
I see him previously, so.
Yes, you want me just to speak a little while until you figure this out? I'm sorry.
I can see you now. We got it.
What happens is, because of the way the system works, if you don't talk and other people have said something, your picture doesn't come up. So you are now very visible. We appreciate it.
Well, good. Although at my age, maybe it would have been better if you couldn't see me. Well, I want to make 2 points, 2 quick points, and then I want to reserve most of my time. The first one is that Travelers has felt it necessary to vilify the Bollschweilers, and repeatedly in their brief, they say things like they misrepresented their workforce, or they operated in an illegal business model, or they didn't respond to phone calls, and somehow this is all their fault. I responded to the first 2 of those. They didn't misrepresent anything about their workforce. The fact that their workforce was different 8 months before than it was at the end of that period only means that it was different. There's no evidence that they misrepresented anything. And they didn't operate an illegal business. They had some contractors that they weren't able to produce a workers' compensation insurance coverage certificate, and therefore the result of that is that they had to include those people in their payroll. There was consequences for them not having that, but that's not an illegal business they were running. There's one thing I didn't respond to in the reply, mainly because I don't think the case is going to turn on this point. But they claimed that they they made phone calls and left messages for the Bollschweilers to set up both the initial the preliminary audit and later the final audit. I didn't respond to that because I just don't think it's that important. They got the audit. The physical audit was done in October of that year. But if you think it's important, whether they got those or not, please look at the affidavit of Mrs. Bollschweiler, and she testified she did not receive those phone messages or phone calls, and that she promptly responded. So it just, again, even if that was an important issue, and I don't think it is, but if it were, there's an issue of fact as to whether or not those phone calls were made or received.
Mr. Arnett, there's a lot to unpack here in this record, a lot of information. What would be helpful to me is if you could give us a list of your bullet points or however you want to say it. But what are the primary factual disputes? What issues or what specific facts are at issue here that should, in your mind, would preclude summary judgment?
Well, the biggest one on summary judgment on their breach of contract claim, of course, is that they took the position that the time records, the time sheets that Mr. and Mrs. Bollschweiler kept were not adequate. Now, everybody recognizes they kept those time records. Everybody recognizes that those time records were given to the traveler's auditor at the time of the audit. And he made a cryptic note in the audit file that said, these are inadequate. And so I took the deposition of a 30B6 deposition, a deposition of travelers. And they designated Mr. O'Connell to come and testify. And he had never, when I took his deposition, seen any of those time records. And he acknowledged in his deposition that he said, well, he said they were inadequate, therefore I guess they were inadequate. He had never seen them. So I showed them to him in the deposition. And when he looked through, I showed him the ones that survived the flood. All of the time records didn't survive. There were a handful that didn't get water damaged when they had a flood in the storage room where they were being kept. I showed him the surviving ones, and I asked him, are these the kind of records you're looking for to divide labor between classes? And he said, yes, that those were. Now, he said he might have some questions about some of them, and that he would direct those questions to Mr. Bollschweiler, and if those questions were satisfactorily answered, this would be enough to divide. Okay, that's the evidence. And so I guess that's probably our strongest point on the reversal of the summary judgment in favor of
Mr. Arnott, this is Judge Weinsberg. So let's, instead of going off on one, give me a list. What are the facts that remain in dispute that should have allowed this case to proceed past summary judgment? I don't care if it's in bullet form, a list, but just what they are. What are the facts?
Well, they are. First of all, there was evidence that their time records were adequate to divide their time.
Okay, so the question there would be whether or not time records are adequate under what standard?
Well, under the standard that that was used by travelers in the 30B6 deposition, where he admitted that they were adequate.
Okay, and what else is it? Can
I interrupt for just a second on that point? Because it wasn't just that they were adequate; it was adequate if they provided additional explanation. Right. That's a more accurate statement of what they said.
Well, yes, but initially.
And is there evidence then that they provided additional information if it was requested?
Yes, all of the information that was requested of them, they provided. Absolutely, and Mr. Bollschweiler himself testified to that, and yes, they provided the information that was asked of them. And remember, there was a second.
I'll let you get back to Judge Weinsberg then. I just wanted to tease out that point. Judge Weinsberg, thank you. I apologize.
Oh, no.
So, I mean, yes, on their breach of contract claim, that should end the question, really, about whether or not there's an issue of fact as to whether those time records were adequate or not. The auditor said they were not, and then they put all of the time for all of their employees in this highest category, and that catapulted their premium amount that they were asked for into the stratosphere, really, as far as it made it 10 times higher than anyone had anticipated that it would be. Another point on the counterclaim that the second point I wanted to make, and I don't know about a bullet point. I mean, we have lots of things that we pointed out in our motion papers below, and again here, that we have a disagreement as to the facts of this case. But I want to concentrate for a second on our counterclaim. We made a counterclaim for breach of the statutory duty to act with fairness. It is the Unfair and Deceptive Acts and Practices Act of the Arizona legislature. And I want, on that one, I really want you to read the Sparks case and the Ward case that I cited in my brief. In Sparks, the insurance company was held liable for unfair and deceptive acts and practices in the business of insurance, that same statute, for failing to put in their policy that insurance coverage on a health insurance policy would terminate when the policy terminated, even for an ongoing injury. And Mr. Sparks had been in an airplane crash and was still in the hospital and still recovering and still incurring medical expenses for something that happened during the policy period. And because Republic National didn't put in their policy that they would stop the coverage for his medical care that for an injury that occurred during the policy period, they were held liable under this same statute for unfair and deceptive acts and practices in the business of insurance for not putting that in their policy. The second case that I really want you to take a close look at is the Ward case. I happen to represent Mr. and Mrs. Ward in that litigation. There, the insurance company, Fireman's Fund, was held liable and a summary judgment reversed on the unfair and deceptive acts and practices in the business of insurance for the failure to call attention in the policy to a change they had made. The original policy, when Mrs. Ward bought it, would covered her for comprehensive coverage if she was driving a non-owned automobile. She borrowed her sister's car. It got caught on fire, and she then found out that they had changed their policy, but they had not called their attention to this. And based on that, they were held liable in the Ward case for unfair and deceptive acts and practices in the business of insurance in a published opinion from this court. So you look at that, and what we have here, this case is better than both of those cases in many ways, that they hid their Rule 26 or Rule 2G among the 2,300 and something pages of the manual, this manual that is an NCCI manual. They didn't give them a copy of that. They didn't give them a copy of this rule. And that's really no different than what they did in Sparks, and in Ward, and not informing them of what the rules that they're going to be operating under. And remember that it was Travelers that wrote this policy. They could have put Rule 2G in their policy if that was what they wanted to enforce. And remember, this is a breach of contract case. So they also hid the short-term penalty. They claimed a right to add an additional 11% based on their now claim, different from what I heard in the 30B6 deposition, that it was us that canceled the policy. Well, it wasn't our clients that canceled the policy. It was clearly Travelers. So those are the 2 points I wanted to make, and I would prefer to reserve the rest of my time. How much time do I have left, Judge?
You are at, and I'm sorry, I can bring it back up. It just takes me a second. 8 minutes and 55 seconds.
Okay, thank you. I was going to hit my timer, and I forgot to when we started. Thank you.
Not a problem. All right, I do need to reset it, so give me just a moment. All right, so counsel, whenever you're ready.
Thank you, Your Honor. May it please the court. Certainly my opposing counsel takes issue with the phrase illegal business model, but surely it is. They have admitted that they misclassified subcontractors as subcontractors, people who are employees. That means that they failed to report that information to Travelers and failed to pay proper workers' compensation insurance for those individuals, and also was illegal in many other ways, failed to pay unemployment, Social Security, FICA taxes, et cetera. It's an illegal business model that we see in this area of law frequently. And by the way, it explains why the appellants avoided being audited 6 times until after the policy had been canceled by Travelers. You don't avoid 6 audits if everything's up to snuff in your workforce. I'm sorry, I believe Judge Brown, you're...
Sorry, counsel, when was the first time that there was a request for an audit? Do you recall?
It's within the first 3 months of the policy, Your Honor. Okay. Travelers does, as a matter of policy, a preliminary physical audit. They come onto your work site. And this is a really critical thing because a lot of appellants' argument is, woe is us. We were surprised that the premium was what it was. But they thwarted the very solution to that problem, which is when Travelers' auditor comes onto your site, they look at your payroll records and your time records, and they say, hey, it looks like you have some subcontractors here who are working on your barns and are going to create risk under the policy. We're going to include the remuneration to those subcontractors as part of the policy. And that did happen here. And they don't dispute that that was proper. But they also would have said, hey, can we see your records that you're keeping? Because it looks like there are 3 codes that for categories of work that this workforce performed. Those codes were supplied by the Bollschweilers. Travelers didn't create those codes. And by the way, critically, those are NCCI codes. And so it's really important to understand there's no gotcha here. The Bollschweilers went to their insurance agent, Kevin Lewis, and they applied for private insurance 4 different times, and they were denied 4 different times. That is a matter of record, and it's right on their NCCI application, which is IOR 55 Exhibit 1. And I think it's really important to understand that it is not the case that the foundational contract here is the Travelers policy. The foundational document here is the NCCI application that is IOR 55 Exhibit 1. That is the document that actually secured workers' compensation coverage for the appellants. And that's really critical because if you go to that document, and here I'm referring to...
Let me ask a question on that, counsel, if I could.
Yes.
With regard to that document, there are codes listed on that document.
Yes.
Can Travelers deviate from those codes? Does it have any discretion, or is it bound by those codes?
In the first instance, Travelers must not only accept the codes provided by the insured, but also the amount of payroll assigned to each of the codes. So this application is submitted to NCCI, which then simply sort of spins a wheel and assigns Travelers to write the policy as laid out by the insured. And therein lies the problem. So Travelers can, if the insured has completely inaccurately described the work that their workforce performs, Travelers could add a code, for example. But they did not do that here. So it's not material here. At all times, Travelers used the 3 codes that were provided by the insureds. And again, they didn't. How did they get the NCCI codes that applied to their workforce? They get those working with their insurance broker when they submit the application to NCCI. And critically, and this is Travelers 207, which is in Exhibit 1 to IOR 55, our separate statement of facts. It's really important to read what Ryan Bollschweiler signed. He signed this language. The undersigned applicant hereby certifies that he or she read and understands the questions and statements in this application. Skipping forward, by signing below, the applicant also certifies that any or all responses provided in or to this application are true and accurate, and applicant further understands and agrees that since he or she has been unable to secure workers' compensation in a regular manner through any other insurance carrier or provider, this coverage is being afforded under the applicable WCIP. So this is, I'll continue, and that the applicable rates and rating programs charged may be higher than those in the voluntary market. So this assigned risk pool is not a Travelers product. It is the Workers' Compensation Insurance Plan, the WCIP, developed and administered by NCCI. And the policy is a form contract reviewed and approved annually by NCCI that's issued after the fact. It's not a negotiable instrument. The Bollschweilers were compelled to enter into this contract just as Travelers was compelled to write it. And so this argument that that Travelers somehow pulled some sort of gotcha or bait and switch is belied by this record. And so when the Ryan Bollschweiler signed this, it said the following. This is again on the same page, Travelers 207. It's the third bullet point. Provided the applicant is determined to be eligible and in good faith entitled to WCIP insurance based upon the information provided herein or otherwise available to the plan administrator, coverage will be bound in accordance with WCIP rules. Not Travelers rules, but NCCI's WCIP rules. They complained about not knowing to keep time records. And if you go just below
Counsel,
yes.
Let me jump in here. So it seems like, to me at least, that the big issue, and there's a couple of side issues I'd like to ask you, but the big issue is when Travelers conducted the audit and finally was able to do it, and were finally given the records they needed, whether the timesheets were adequate, verifiable, reasonable, whatever kind of word you want to throw in there, isn't that the rub here? Isn't that what we're talking about in this case? I'm putting aside the counterclaim, but on the breach of contract claim, why isn't there a factual issue there, especially when you're throwing out words like that to me seem fuzzy? And so how shouldn't those types of issues go to a jury to decide whether those records were not, as opposed to somebody saying, well, it wasn't quite good enough? Well, what was the target that they needed to hit?
Yes, Your Honor. And I do believe that there is a mischaracterization of the Travelers representative's testimony. So here, and again, I want to emphasize that if the appellants had not thwarted the preliminary physical audit, this would have been explained to them. It was that what verifiable records are, and indeed, appellants have shared that that they now keep the properly allocated time records, and so it is something that payroll systems can do. So again, they thwart being audited the entire policy period. There's only an audit after the policy period has ended, and by then it was too late for them to maintain the correct records. But here's what the testimony shares, and pages 25 and 26 of our answering briefs.
Before you move on, counsel,
yes.
Is there any dispute about whether they in fact thwarted the audit attempts?
I mean, I don't believe that it is a colorable dispute or a material dispute, because, Your Honor, I mean, Travelers reached out to the insured, and the insured ignored and didn't return multiple phone calls. And they say that they didn't get one or two of them. There were 6 total efforts, all of them thwarted. This isn't, I mean, it's revisionist history to kind of come back. This wasn't over a period of weeks. This was over a period of a year. And so I just think it is revisionist history to say, oh, shoot, if we only knew you were trying to get a hold of us, we would have opened up our doors and welcomed you in. That's not the record.
So let me ask you this then, because I think it's Accord 133 advises the insurers they have to keep and maintain complete records of payroll transactions as the insurer may reasonably require. And I want to understand, is what the insurer may reasonably require? I'm not sure that that's factually disputed, that what the insurer requested was unreasonable. But then isn't there a dispute, as counsel has pointed out, as to whether or not they provided those documents. So I guess answer both. Is there a dispute on whether the request was reasonable? And then is there a dispute about whether or not you folks got the response once you requested it?
Yeah. There's some dispute as to timing, but we do not dispute for purposes of this hearing that their receipt. And those records are at IOR 55, they're paragraph 38, exhibit 19. And they're handwritten records, and they are extremely vague in general. So we would normally want payroll records that assign this 30 minutes to this code, et cetera. And that's what would have been explained. That's what Travelers expects.
Yeah, and counsel, just let me, okay, so that is it's every 30 minutes? Is that what because I've never, you need to have it counted for every 30 minutes of the workday?
Well, no, Your Honor, I didn't mean 30 as like the only or the standard. I mean an 8-hour workday for this individual, 3 hours spent on code, 5509, 2 hours spent on this code, 3 hours spent on this code. So the way that these codes work, the highest rated one is when your individuals are working on roofing that is 2 stories or less that has a steel frame. And that is particularly dangerous work. There is, sworn testimony that they were working on ladders. So in this instance, we would have needed a record of how much time were you doing roofing work in the air, that high risk work, versus time you might have been on the ground doing work that is lower risk. And the records do not reflect that. And so I want to circle back to the question about the specific time.
Ask you this before you do. I don't want to take you away from that for too long, and you're at about 7 minutes. But some of the time cards are at least specific, and at least for one employee. But it seems like Travelers said, okay, even for that employee, everybody's 50-59, and just did a broad sweep. And isn't there at least an issue as to whether for some of them, for some of the time, there was enough information that they could have parsed specific times out?
It's a good question, but I think what's happened here is appellants have sort of tried to create a new record after the fact record, saying, hey, wasn't this sufficient? The best and most contemporaneous evidence comes from the auditor themselves. The auditor specifically wrote, quote, no time carding performed between structural erection work less than 2 stories and sheet metal siding work, all to highest rating. So what this auditor was looking for was time cards that show the separation between structural erection work and sheet metal siding work. And the auditor...
Counsel, let me jump in there. So, but for instance, Mr. Jordan Ray was one of the employees that, it's my understanding that there was no evidence or nothing from the time records that would reflect he ever engaged in roofing, that he had a different job that had to do with fencing or something like that. Why would he be put into the highest classification?
Yes, Your Honor. I think that as to him, the record doesn't show any indication of his time card showing which tasks he performed. Remember, the 3 codes were chosen by the insured. And I think that what happened here is late in the audit process, long after the policy had concluded, the insured is saying, essentially, trust us, this individual didn't perform roofing work. Well, Travelers had every right to request written records that established that he wasn't performing any roofing work. They didn't provide those, and Travelers candidly had a bit of a trust issue with this insured that had an entirely different business model than they disclosed on their application, had not disclosed subcontractors they were using, and had thwarted their prior audit efforts. So Travelers followed the Rule 2G by NCCI and said these records are not sufficient to establish which codes were worked on during which time periods. And Rule 2G, not Travelers Rule, NCCI's rule, declares what happens in that instance.
Hey, counsel, I know you're going to run it short on time, but just could you briefly address the 11%, well, I don't know what to call it, addition or additional add-on for the cancellation? Who canceled the contract, and how is that 11% addition supportable if it's part of the court's judgment?
Yes.
And you've got 4 minutes, so you know.
The short rate cancellation, it's specifically quoted in the policy. And so the only issue that appellants raise is who canceled it. Well, the record's pretty clear on this point. By the way, it's IOR 55 Exhibit 9, page 5, that states if you cancel, final premium will be more than pro rata. It will be based on the time this policy was in force and increased by our short rate cancellation table and procedure. And so here, insureds used a premium finance company, Imperial PFS, and the appellants granted that premium finance company power of attorney to cancel the policy for non-payment. Appellants failed to pay, and the premium finance company canceled the policy. That is at IOR Exhibit 13, which states, quote, the premium finance company has exercised its right to cancel this policy. The premium finance company has exercised its right to cancel this policy. The premium finance company was acting with the appellant's power of attorney, and that is why the appellants canceled the policy. But it does lead me, there's so many points I'd like to make, but it does lead me to something that I don't want to miss the opportunity to address. It's really, we
You have
think
2.5 minutes, so you know.
We think there is no material issue of fact here, but in a telling argument on page 47 of their opening brief, the appellants argue, even if summary judgment had been proper, the amount of that judgment was subject to issues of fact. Now, as to the time record issue, we think the auditor, and if you review O'Connell's testimony in pages 25 and 26 of our brief, that process was handled properly. The audit was done properly. An attempt years later to sort of nitpick and say, boy, weren't these records, isn't there enough information in there? I don't think that's a proper way to address it. But that, as to these other facts, $119 payment and the short fee, it's a pretty remarkable argument to say that is a dispute, a genuine fact that should go to a jury. Liability for breach of contract has been established here, and judgment as to liability must be entered. Travelers, they clearly did not pay premium due to travelers, which establishes a breach of contract. There's really no dispute. Their dispute is as to calculation. And we also think on the counterclaims, there's simply no dispute of fact as to the counterclaims. And I would even add, even if there were, the damages issue is dispositive. They absolutely and utterly failed to disclose any damages, and that alone means that their counterclaims must be dismissed. But as to this one issue that they seem to be focused on, the amount of damages, do they want to have a jury trial in which the trial court has already awarded our attorney's fees, and we get to the end of a trial and maybe they owe $5,000 less, but they owe our attorney's fees in their own? Is that really the result that appellants seek? And so I want to mention to the panel something you already know, which is even if there were a dispute of material fact as to the short rate cancellation fee or the $119 payment, we would humbly suggest that the better approach would be for the court to simply remand to the trial court with instructions to remove those two items from the judgment, which is a far better result for the appellants than having to go to a jury trial with with liability already established as to the damage.
And you're at your time, counsel.
Thank you.
Thank you. All right, I need to reset, and I believe I'm going to 8:56, correct, counsel?
I'm relying on you.
All right.
All right. Well, let me kind of address these maybe in the reverse order, just because it's most recent in our memories. There is no power of attorney in the documents. There is no and more than that, the policy doesn't say we get to impose this short rate cancellation fee, and we want to call it 11%. It happens to be 11%. We have never, ever seen the actual schedule that they claim exists, ever. They said, we'll do this short rate cancellation if you cancel the policy early, and it'll be according to this schedule that we have never, ever seen. I don't know if it says 11%. I don't know if it says 2% or if it says any other number. We don't know. That's never been produced, and it's their burden of proof. So, and also, it should have ended the whole dispute.
Did you argue that below? That you've not received that schedule and that schedule should have been produced? Or was it requested?
I did not request it. And let me explain how this came about. I had no idea where, and neither did our clients, where this extra charge came from. And there's a different terminology than in the policy. One of them calls it a short rate, and the other one calls it a short something else. The word short is in both of them, but they are very different from each other. And they never said to us, they never said in any of the documents that were sent to them after the audit, we're adding this because you canceled the policy or under this provision of the policy. None of that was done, and there was no discovery about that either. They never disclosed to us. That's why we're charging this 11%. So what happened was they moved for summary judgment, and I pointed out, wait, there's even if you were going to give them some money in this thing, that the amount of the judgment is in dispute. And yes, I did point out we don't have this schedule at all. The short rate cancellation schedule has never been produced. But more important, it wouldn't matter if it had been produced. If they're going to impose an extra penalty, that short rate penalty needs to be in the contract. You don't get to hide it in some other document somewhere, in some schedule that they keep in some secret file in their office. That's not allowed. So first of all, you just don't get to do that. You don't get to hide that. And again, it's further evidence of unfair and deceptive acts in the business of insurance on our counterclaim. I want to say one other thing on the short rate penalty. When I asked in a 30B6 deposition of Travelers who canceled this policy, he said, we did, for non-payment of premium. Now, if at the very least, we have an issue of fact as to whether or not whether Travelers spoke correctly, and I should be able to take that to the bank. At least the way I've been taught to do business, when you take a deposition, a 30B6 deposition of Travelers, and Travelers says under oath, we canceled the policy, that should be the end of the dispute. And you combine that with the way the policy says it gets canceled, it has to, if the plaintiff cancels it, if the insured cancels it, they have to send a letter asking for cancellation. There's no such letter. If the insurance company cancels, the insurance company sends the letter informing them of the cancellation. That's exactly what happened here. There's no question about who canceled the policy. On the preliminary audit that he mentioned, there's some rule that if you go to a preliminary audit, you get to change the contract language. The contract language says exactly what sort of records they have to keep. And that language is in the contract, and they kept those records. And so it's not like if they'd had a preliminary audit, the auditor could come in and say, oh, well, and by the way, we're now going to orally change the terms of the contract. That is never permitted.
But hang on, because the contract does say provide the records that they request. And had the preliminary audit happened, there's every reason to believe that they would have requested the clarification they're asking about now and ask about later. How is that not the case?
Well, the point is they don't get to change the contract and say, oh, we're going to require something different than the contract requires. That's my point.
But the contract says that your client would provide the documents they requested. And then your client didn't participate in the audit. And so there was no way for them to request the documents that they needed to make that clarification.
They didn't have a preliminary audit. They did have the audit at the end of the policy. We want to make sure that's clear.
No, I understand.
Yes. There was never a preliminary audit.
If they had the interim, they certainly could have started to provide the time records that were needed earlier.
But oddly enough, go ahead. I'm sorry.
No, that's okay. Go ahead.
Well, but oddly enough, the time records they kept, according to travelers in the 30B6 deposition, were adequate. And I want to make this point too. There is no requirement that in the time records that they keep, they allocate it by code number. In fact, I asked that question specifically. I don't have the reference to that in the 30B6 deposition, but I know it's in the papers and certainly in the statement of facts that we responded to in the court below, that you do not have to, and Travelers does not require any code numbers to be in the time records. That's perfectly clear. You don't have to put in, this is code number whatever, and this is code number whatever. All you have to do, and all that's required, and Mr. O'Connell made this perfectly clear, all you have to do is say what they did, the date they did it, what sort of activities they participated in. That is all that is required by Travelers and certainly by the policy. I just have a couple of minutes left. Let me. I want to make it clear too that this policy that was issued is not an NCCI policy, and this is a Travelers policy. They wrote this policy. They submitted it to the Department of Insurance for approval. It is their policy. It says Travelers all over it. And what counsel said a few minutes ago, there's no evidence in the record that NCCI reviews these policy forms or approves them in any way. They're just workers' compensation policies. Now, yes, NCCI requires all insurance companies that do workers' compensation business in Arizona to participate in this assigned risk plan. Yes, and they were forced to issue this policy. I get that, but there's no evidence of what Mr. Kroger said that NCCI reviews these or has anything to do with that at all. So
you're basically at a minute, counsel.
Excuse me?
You're basically at a minute.
Okay, thank you. Well, yeah, let me spend the last minute on Jordan Ray. If they're going to sue us for breach of contract, and they're going to claim they're entitled to more premium, it is their burden to show that Jordan Ray did some work, at least on some day, in that highest category. And they have absolutely no evidence of that. And by the way, he is so heavy, he can't even get up on a ladder. He's never been on the roof. They have him do jobs down below because of his weight. But he'd never been on a roof. There's no evidence that he ever was. And Mr. Bollschweiler explained that to them. They had access to his time records to demonstrate that. These are records we no longer have because of the flood. But that is, and so there's simply.
We are at your time, but I need you to just answer this question.
Yes.
Isn't it the employer who has the burden of proof? Sorry, I'm trying to make that stop now.
Yeah, mine just made some noise
there
too.
We go. It's the employer's burden to show what work was being performed, not the insurers. Isn't that the case under the policy?
I don't think the policy says who has the burden of proving in an audit, what the facts were. Even if it is our burden, he proved it by his own testimony, and he has Mr. Ray also. I mean, they asked him about it. He said by his testimony is Mr. Ray never went on the roof, and therefore there's no evidence really that he was ever on a roof. All right. Well, my time is expired. Thank you.
And we appreciate the argument here today. We are going to take the case under advisement, and we'll issue our decision in due course. And we are going to stand at recess while we set up the next argument. We apologize for some of our technical difficulties. We're hoping that the next one goes smoother because we're already behind time. Have a good day and stay safe, folks.
Thank you. Thank you.